Can a federal conviction related to a sex offense result in a sexually violent offender designation? To find out, you have to read People versus Sherlock, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Sherlock. The citation for this case is 2025 New York Sub-Opinion 02966, published by the New York Court of Appeals on May 15th of 2025. The issue in this case is whether a federal conviction can result in a designation as a sexually violent offender under Corrections Law 168A3 and the Sex Offender Registration Act in New York. To understand and appreciate the context of this case, what's helpful to know is that the Sex Offender Registration Act is a long statute. It's under Corrections Law 168 that describes a whole long procedure for how the courts treat a person convicted of a sex offense in New York and outside of New York, which they call foreign jurisdictions. So if it takes place in New Jersey or federally or Alaska or Hawaii or another country, it would be considered a foreign conviction. And at a SORA hearing, a Sex Offender Registration Act hearing, the judge considers the evidence presented before it and gives a risk level. Risk level low is 1, 2 is moderate, and 3 is high, but also considers an application for a designation. A designation, such as a sexually violent offender, is basically an automatic, what it accomplishes, it's an automatic lifetime registration. So for a level 1, a person must register for 20 years if you're a risk level 1. But if you have a risk level 1 with a sexually violent offender designation, it's lifetime registration. It's registering annually for life. But there's different ways to get a designation of sexually violent offender. 3 different ways. The first way is there's a list of convictions. So if you're convicted of rape, it's a sexually violent offender designation. So there's a list of specific crimes. The second way is what's called the essential elements test. So it's from a foreign jurisdiction. So if you get convicted in Montana of a crime that's not registrable in Montana as a sex offense, but if all the elements of the conviction match all the elements of a conviction that's in the designated qualifying offenses list, then you could be designated as a sexually violent offender. But the third way is the one that's relevant to this proceeding, which is if you're convicted in another jurisdiction and register in that same jurisdiction of the conviction, then, so if it's a conviction that results in registration in that same jurisdiction, then you're a sexually violent offender designation. What are the facts in this case? The facts are the defendant was convicted in New York of a federal offense. He's convicted of possession of child pornography, many pictures, and he was convicted of that and had to register in New York as a sex offender. The people at these hearings, the Board of Examiners prepares a report saying what they think the defendant should be assessed in terms of points. That would determine what level he would be. But the hearing, the people can present their own point assessment, and the judge has to determine what assessment applies. The board recommended a level 1, and they recommended no designation. But the people recommended level 2 and a designation as a sexually violent offender based upon the federal conviction that resulted in a registration as a sex offender. The defendant opposed that, but the judge found him a level 2. This is a Suffolk County case. Judge found him a level 2 and found him to be a sexually violent offender, gave him that designation, which would result in a lifetime requirement for registering as a sex offender. The defendant appealed to the appellate division. They affirmed what the judge had done, and it goes to the Court of Appeals. The question here is, does that federal conviction that results in a state registration, does that satisfy that subdivision of designation that says if you're convicted in a jurisdiction that requires you to register in that same jurisdiction? And the Court of Appeals says, because here, the Court of Appeals says, no, it does not. The Court of Appeals says the fact that the defendant was convicted in a federal jurisdiction that resulted in a state registration means it's a different jurisdiction for the purposes of Corrections Law 168A3. And because he was convicted in a foreign jurisdiction, he should not necessarily be designated a sexually violent offender because it's a different jurisdiction. It's sort of an equivocation fallacy, using the same words for two different ways. Jurisdiction can mean, what kind of court system you're in, and jurisdiction can also mean what geographic location you're in. And the meaning in this particular statute is, does the system that convicts you also require you to register in that same system. And in federal world, there's no federal registration. It's just a requirement in the statute called SORA that you register in the state in which you were convicted. And that's the case of People versus Sherlock. So the designation is removed, and that's the holding of People versus Sherlock. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.